Okay, good morning and welcome to today's webinar on behalf of probono.org. Today we'll be discussing reducing HIV, AIDS and TB stigma. And we're very privileged today to have two very experienced speakers in the area of stigma and discrimination. It's Emma Weber from Victoria Mxenge group of advocates and Mabalane Mfundisi from Show Me Your Number, which is a very well-known NGO working in the field of HIV/AIDS. And I'd also like to introduce some staff members from probono.org, and that is Teresa Yates and Alice Brown. Teresa Yates is the Executive Director of probono.org, and she will be giving us a short introduction on what Probono is, specifically this project. Teresa, if I can hand over to you.
Thank you, Chantel, for the introduction. And I'd just like to thank everyone who has taken out time to sit in on this webinar live and or listen to the recording later. This webinar is part of a series that's funded by the AIDS Foundation of South Africa through a generous grant from the Global Fund. And to fight HIV, AIDS, and TB. Pro Bono's specific role within the project is to raise awareness around stigma and discrimination within HIV and AIDS, and to provide legal support for individuals in South Africa who may be facing discrimination and or stigma based on their status. So through the project, we've provided training for paralegals. We're linked to paralegal community advice offices across 35 districts in South Africa. Through those engagements with those offices, we have provided training as well as some legal support to people within the communities that those advice offices operate in. So we're very excited to co-host this webinar, and we hope that everyone who is attending will find it informative and useful. And we encourage anyone who may be listening in, who may think that they need legal assistance with regards to any challenges they may be having, legal challenges they may be having based on their status, to please contact probono.org, and we will do everything that we can to assist. So I'll turn it over to the speakers. We're very happy to have Emma Mabalane and Dr. Eric Heffer, joining us today, and I'm excited to listen. So thank you.
Thank you very much, Teresa. So without further delay, can I hand over to Mabalane to start giving an overview about the type of work that Show Me Your Number has done in terms of reducing stigma with people living with HIV/AIDS. Mabalane? And please also just give a brief introduction of what your organization does.
No, thank you very much, Chantel, and morning other panelists that are going to engage with us. Show Me Your Number was born out of the work done by the South African Football Players Union. Every time people ask, what is Show Me Your Number? And we always try and explain, because it sometimes sounds funny, like it's not a serious organization. But for us, it is to ensure that we use the power of sporting platforms, sporting personalities, arts and culture in the prevention, as well as addressing HIV, TB, and STI, but through a human rights lens. So our work is, premised on a number of program areas: community engagement, where we provide services to, in terms of HIV demand generation. It's also around our advocacy work, which is linked to our human rights program, and it is within which this context that we are participating in the human rights program of the Global Fund coordinated through AFSA as part of the South African National AIDS Council. And our work there is really to address issues of stigma and discrimination that the key and vulnerable populations experience. And key and vulnerable populations would be people living with HIV, people who have had TB, sex workers, people who inject drugs, adolescent girls and young women in the main. So as the most vulnerable in society, especially in terms of provision or accessing health services, our role is to popularize how to use the law as a platform for advocacy. But in order for you to arrive at using the law as a platform for advocacy, you need to identify and record the issues that require you to take them to those that will assist you. So this engagement will enable us to appeal to the health, to the legal profession to join hands with us, to walk and work with us as we do this particular work at communities. But most importantly is to ensure that people do understand the limitations and the things that can be done in terms of provision of those particular services. So in a nutshell, that's really who and what we do as Show Me Your Number. Thank you, Chantal.
Thanks, Mabalane. You can continue with your presentation now.
Oh, let me go to my presentation and share my screen. Okay. I've already spoken about who we are, Show Me Your Number, our vision, our mission, and the values that informs us as an organization. In terms of the background to the human rights program that we are implementing in terms of the Global Fund, there's three things that are very critical. One is, this is based on the National Strategic Plan on HIV, TB, and STIs 2017 to 2022 that the South African government approves, and it is implemented through the South African National AIDS Council. Within this strategy, there is goal number 5, and goal 5 it's through the goal through which the human rights program are being operationalized and implemented. And this is done through the comprehensive response to human rights related barriers to HIV, TB, and gender inequality in South Africa, which is a strategy that was approved last year. That was approved the South African AIDS conference in 2019. And this program really lays the basis for the implementation of the human rights program of the Global Fund, which is called Breaking Down Barriers. In that program, there's quite a number of organizations that are implementing a recipients under the Global Fund PR, and Show Me Your Number implementing the module that speaks to addressing stigma and discrimination. Now, for us, in terms of this engagement, we're looking at the law as a tool for advocacy. What is legal advocacy? As you would know, advocacy is advocacy through the courts, but it's about using the judicial system to advance social change goals. It's often done by bringing forward a legal case, to court, in terms of focusing on improving a situation for a particular group of disadvantaged people. In our case, the group has been identified as what we call KVPs, or key and vulnerable populations, that have already outlined. People living with HIV, people living with TB, adolescent girls and young women, people who inject drugs, sex workers. But it's also about identification of human rights issues that affect these key populations. So the interface between the issues and the communities on the ground is key and critical, because about proper documentation of those issues, ensuring that they fit the criteria that we have to be addressing, and using the test cases to ensure that we challenge the duty bearers to do the things that are required of them in terms of their day-to-day responsibilities, as well as how they are outlined in the Constitution. So doing all of this, it's about breaking down barriers, which is for us bringing forward cases through the courts to advance for change. There has been a number of lessons that we have learned in this particular journey, working with 25 organizations in 25 districts, ensuring that they understand properly what the issues are in terms of human rights, how to document them properly, and ensure that they are taken through the correct channels, and ultimately using the power that pro bono has in terms of sifting through those particular issues or cases, and taking the cases that require us to take them forward, so that those that act with impunity can be put to book, and we change the situation of key and vulnerable populations. So what is the role of civil society organizations like ours in that particular journey? One, it's about identification of human rights issues at community level through focusing on these key and vulnerable populations. Secondly, it's about advocating for action with duty bearers to address the human rights issues that have been identified. Thirdly, it's ensuring that there is an ongoing training and capacity building to ensure understanding of human rights approaches to support advocacy. Some of the organizations that are involved in this program, we're focusing on addressing orphans and vulnerable children, and they were not working in the space of law and human rights. So it's reorientating and ensuring that they understand what it is that we are trying to do, and then going into their communities using their agency to ensure that they identify those particular issues. The fourth area is around strategic partnerships that we as civil society organizations, and in this case pro bono and others that pro bono has brought to the fore, to ensure that as the people in the legal profession, they support the work that we are doing in terms of human rights. At some point, it's not just taking cases to court, but it's also ensuring that there is a broader understanding of what constitute human rights barriers, how to better understand what needs to be done in order to address those issues, because sometimes it's because people don't understand that they do the things that they do. So our role is to ensure that we knock on the doors of those that understand these issues better, and then work with them to take action. The fifth area is around using various media platforms to communicate human rights abuses, because the more we talk, the more we get through each other, and ensure that there is an understanding and people act differently and act better. This forms part of social and behavior change, because you're not going to just have social and behavior change by putting people in a classroom, but it's continuous engagement, so that people unlearn the bad things that they may have learned through childhood, or through their friends, or through other things that influence how they see the world. And lastly, it's us as leaders of these civil society organizations being messengers in advocating for the human rights, a human rights-based approach, because the message is as equally as important as it is from the messenger as well. So us understanding what the issues are and using our agency to ensure that we drive those particular issues, that is part of the role that civil society organizations have in terms of advancing a human rights agenda. In the last part, it's really our ask of you as the legal profession. And for us, there's 5 things that we are asking. For you to be strategic partner of civil society in promoting human rights through the law by doing the following. 1, being trainers on legal advocacy. We all don't understand the law, and when we have people that better understand the law, break it down so that the law becomes a useful tool in terms of what we need to do, becomes a key and critical component of what will empower us. The second one is being speakers on activities arranged by civil society in terms of human rights. And civil society, they are the Rolls Royce of civil societies, and there are the jalopies. So your participation in the Rolls-Royce conversation is as equally important as with those that are the the jalopies, because if we have a broad understanding of the issues at the local level, then that will translate into broader understanding and advocating of those issues through those that get various media platforms that enable them to massify what they are doing. So when an invitation comes, it must not just be from the the big hitters. It must also be from the small players, because when we do that, we are able to move this wheel forward. Thirdly, it's about being available to provide legal services pro bono for human rights cases that are identified. The work that pro bono is doing, and when the cases come, it might not be enough only for pro bono to run with those particular cases. They will need others to be on board with them to help support them. So we are calling on you to join to join pro bono in the work that it has outlined that it needs to do. And it's also about serving on the boards of civil society organizations, because the boards provide strategic direction in terms of where we need to be going. And it is when we have boards that are solid, that have professionals that understand the issues, that we can be able to make greater impact at the local level. And lastly, it's ensuring that that which you are doing is done even more by establishing legal aid clinics that provide services to civil society. So Chantel, in a nutshell, that's really who we are, the work we have done, and the ask that we are making in order to ensure that we indeed use the law for our legal advocacy in driving and making South Africa a better country for all. The law must not just be for those that have money to afford the lawyers, it must be for all of us. But the law is not about getting into courts. It's about us understanding what the limitations are, what the things that we can do are, and continuously engaging with each other to make South Africa a better world. Thank you. Oh, Chantal, my piece is done.
Thanks, Mabalane. So you've given some very practical suggestions for lawyers to get involved, and I hope that our viewers today will definitely. Yes, thanks. Thank you for that. So yeah, I was just saying that you've given some very practical suggestions. And I hope that the lawyers that are watching this morning will take you up on that offer. So I'd just like to hand over now to Emma Weber. She's an advocate who will be stigma and discrimination through a legal lens. Emma?
Thank you, Chantal. Can you hear me? Chantal, can you hear me?
Sorry, Emma, we're battling to hear you.
Can you hear me now?
We can hear you, Emma, loud and clear from my side.
Yes, I can hear you, Emma.
Okay, fantastic. I think it might be Chantal's screen alone, hopefully, that is struggling. I'm going to proceed then, and thank you. Like Chantal just said, I'm going to approach this from a legal perspective. So we've heard a legal activist's perspective, and we'll hear from a doctor. But I want to give you the lawyer's perspective, particularly on stigma, how the courts have responded to stigma, and ways we can advance the project of reducing stigma. And what I'm going to do is first I'm going to go through a few sample cases to look at how the courts deal with arguments based on stigma and the sort of pronouncements that they've made. Then I'll look at the legal avenues that are open, and we've already heard a fair amount about that, so I won't touch on that for too long. And then lastly, I'll deal with how to improve chances of success for litigation in legal cases that are in fact brought on the basis of HIV discrimination or other issues relating to persons with HIV who have been mistreated in some aspect or whose rights have been infringed upon. Now, I'll start by taking you through some of the cases, and there are a number of cases that are based on the idea that on an invasion of privacy, and there are a large number of these in the early 1990s or 1990s, early 2000s, where it's about an HIV person, a positive person whose right to privacy and to have their status remain privacy was invaded in some way. And often those invasions are justified by arguments that are based on stigma, and the courts have responded quite strongly against those. So a very good example is a case called Janssen van Veeren versus Kruger from 1993. And this went up to the appellate division. And that stage, you know, it was before the Constitution as we now have it, but it was based on ideas of privacy then. And what happened was there was a man who is called M, and he contracted AIDS, and he instituted action for a breach of privacy against his doctor, his medical practitioner, for revealing his status to two other people who were his dentist and another doctor of his. And he lived in a homosexual relationship with his partner, and that was generally known. And he had to submit a blood sample for a test in order to qualify for life insurance. And in doing that blood sample, they tested it for HIV, and he came back as positive. And that result was shared with his doctor, who was then asked to convey the information to him. So he had a consult with his doctor, discussed it, and his doctor told him about his status. And he was very distressed and expressly said to his doctor, please keep this confidential. I don't want other people to know about it. Because obviously stigma at that stage was very high. And his doctor agreed. And in any event, his doctor should have kept it confidential because of their doctor-patient relationship. But the next day, the doctor went golfing with these two other people, the dentist and another doctor of this particular man, M. And during that golfing session, he revealed to them that M was HIV positive. And M then sued him for revealing the status, because then those two knew, and it spread around the whole town. It was quite a small town. The whole town knew about it, and his right to privacy was invaded. And in the matter, M lost in the High Court, but then it went on to appeal in the appellate division. And he sued for damages against this doctor. And the doctor's defense was that he said, well, for an invasion of privacy, you can have various defenses which are similar to defamation law defenses, which include the defense of qualified privilege. And what that is, it says you can convey information to someone else if you feel that there is a social, legal, or moral obligation for you to tell that person this information, and they have some kind of social, legal, or moral right to hear that information. So sometimes it might be that you'd say, if you know that someone is considering killing his wife, and you're a friend of that person, and you hear about it, and you were to tell his wife, you tell his wife because you feel that there's a legal or moral or social obligation to tell her that, and she has a right to hear it, or you have a duty and she has a right. And so that's the sort of context in which that kind of breach of privacy defense would function. So the doctor argued that he had a social or moral or legal duty to tell these other doctors because they would be put at risk, because they would see this HIV positive person, Mr. M, and they would interact with him. And the court heard these arguments and didn't entertain them at all. It found that there was no basis to say that these doctors would be at particular risk. And there was no obligation or moral obligation to tell them that, in fact, there was a obligation of confidentiality and confidentiality within doctor-patient confidentiality. So by telling these other two individuals that there had been a breach of confidentiality, and the court then then awarded the damages claim against this doctor, which is very interesting because that's before the Constitution, before the right to equality has, our final Constitution's right to equality has really become entrenched. And they do that on the basis of common law, and they develop that. So it shows already at that point, courts were, those courts at least, and the higher courts, were quite condemnatory of these arguments that were clearly based on what seemed like ignorance and prejudice. And as an aside, an interesting thing is Edwin Cameron was actually the advocate in that matter for him. So he represented him, which shows just how involved sort of people were, activist communities and in touch activist communities were. There's another case then in 1996, which is 3 years later, that's useful, which is about the invasion of privacy. And that concerned prisoners' rights to privacy when there was about testing, HIV testing. And the court, the department at the time had a policy of informed consent. So you weren't allowed to take blood from a prisoner and test for HIV without first fully explaining the circumstances, counseling that prisoner, giving them an opportunity to reflect, and then taking the test. So it was a whole procedure that was supposed to be followed. And in this case, there were a group of prisoners, they were put in a row outside in a passage, and they were told that there would be HIV testing, and they weren't really given an opportunity to reflect on whether they wanted the test or not. They were also in front of each other. They weren't really given counseling, so there wasn't someone who was trained in counseling. And when they went in individually to the consulting room, there was another prisoner present who was assisting with the doctor, and again, they weren't given consulting. And this is an instance where the court stood up for a vulnerable population. So often prisoners don't get a lot of protection in society, at least, or a lot of regard. And there are many cases around HIV involving prisoners. And they often are considered less sympathetic parties in court, or many lawyers worry that they'll come across as less sympathetic. But the court took quite a strong stance again in this case and said, no, in these cases, it's vital that there is informed and free consent, and that there must be proper time for people to consider their position, proper time for them to get counseling, for all the circumstances of the test and the implications of the test and the disease to first be explained to them. So again, this is a case where the courts side quite strongly on the side of the HIV positive person, which is encouraging information. Then the next case I want to take you to is the case of Hoffman versus SAA. And this was a case in, just lost the reference, one moment. It's a case in 2001, I believe, yes. And this case went all the way up to the Constitutional Court. And it's the seminal case that considers and talks about discrimination against people with HIV. So whereas the previous cases were about an invasion of privacy, this is a more direct discrimination, an unfair discrimination in an employment context. And the facts of this case were that Mr. Hoffman was one of 173 applicants for positions as cabin attendants or air hostesses or air stewards at SAA. And there was a long selection process, and it was whittled down, and he was finally one of 12 that was considered suitable and qualified to play the role as a cabin assistant. But this selection was subject to his undergoing a pre-medical examination. And that examination included blood tests for HIV and AIDS. And they found in the medical examination, they found that he was physically fit, he was fully capable of carrying out employment, but the blood test showed that he was HIV positive. And that then went onto his medical record that's read HIV positive and automatically then rendered him unsuitable, is what they classified him. And SAA said to him that he couldn't be employed as a cabinet attendant because of his HIV status, his positive status. And he then went to court and challenged the constitutionality of the SAA's refusal to employ him because he said it was unconstitutional, it constituted unfair discrimination against him solely based on his HIV status. And SAA defended its refusal. And I'm going to tell you, it did it on various grounds, that it said it was its employment practice for cabinet attendants that all people who were HIV positive were unsuitable. And it justified it on safety, medical, and operational grounds. And on the safety and medical grounds, it said, well, SAA cabin crew flew all over the world, and this included areas where they had yellow fever, and it required that flight attendants be vaccinated against yellow fever. And a person who were HIV positive might have a negative reaction against a yellow fever vaccine, and so couldn't be vaccinated. And then they said, well, this created a risk that they would contaminate other passengers with yellow fever or transmitting other diseases, opportunistic diseases that HIV positive persons are more vulnerable of contracting, and transmitting those to other passengers. And they said that in addition, flight crew who were very ill with these opportunistic diseases and AIDS wouldn't be able to carry out the emergency safety procedures required of them. So they said that on that basis, they were refusing employment. And if you look at these arguments, they seem to be based on ignorance and prejudice to a large extent, because they're saying all HIV positive people, no matter how healthy and well they are not suitable because they are at risk of opportunistic diseases and they're at risk of infecting passengers with other diseases. But surprisingly, the High Court bought SAA's arguments, and they upheld those arguments, and they dismissed this application that was bought by Mr. Hoffman. So he then appealed, and it reached the Constitutional Court. And the Constitutional Court considered whether this was a case of unfair discrimination. And when doing that, they had to determine a number of factors about unfairness, which include looking at the position of that particular person in society, if they've suffered previous disadvantages, what the nature of the discrimination, what the purpose of the discrimination is, and whether it impaired the dignity of the victim. And this is what is interesting, is that the court considers all of these factors, and it makes incredibly strong statements that condemns discrimination against HIV positive persons. And I want to read you one particular extract because it's very powerful. The court says, people living with HIV are a minority against whom society has responded with intense prejudice. They have been subjected to systemic disadvantage and discrimination and have been stigmatized and marginalized. They are one of the most vulnerable groups in South African society. In view of the prevailing prejudice against HIV positive people, any discrimination against them can be interpreted as a fresh instance of stigmatization and as an assault upon their dignity. The impact of discrimination on HIV positive people is devastating, even more so when it occurs in the context of employment, as it denies them the right to earn a living. And the courts held that on the medical evidence, which it's important to note at this point that the AIDS Law Project wasn't in the High Court, so it wasn't a party, but it intervened as a party at the appeal level. And the AIDS Law Project put forward all sorts of expert evidence, medical evidence, which showed that the medical reasoning underpinning SAA's justifications was completely flawed. And there simply wasn't good medical evidence for what they were saying. Firstly, they said many HIV positive people are asymptomatic and are perfectly healthy and able to perform the requirements and the position of a cabin attendant. And they said any hazards which an immunocompetent cabin attendant might be exposed to could be managed by counseling, monitoring, vaccination, and the administration of appropriate antibiotic prophylaxis if necessary. And the risks to passengers and other third parties were therefore inconsequential, and that there were many universal precautions that could be utilized. And so the courts made strong findings against SAA, and they said they understand that there are commercial considerations and there's a need for SAA to show that they care for that they're protecting their cabin and their patients, but there's simply no justification in this circumstance for them to do so. And particularly for them to have a blanket ban on people who are HIV positive. They also said that if, as a nation, South Africa was to achieve the goal of equality fashioned in its constitution, prejudice, whether direct or indirect, could never be tolerated. SAA, as an organ of state, had a duty to uphold the constitution and could not avoid that duty by bowing to prejudice and stereotyping. And so they found that the denial of the employment to the appellant, because he was living with HIV, had impaired his dignity and was constituted unfair discrimination or was unconstitutional. So what is very important about this case is that this comes from the Constitutional Court, which is the top court in the land. Its judgment bind all of the courts below it. And these are very clear and strident statements that talk against discrimination and stigma of people living with HIV and AIDS. And there's strong statements against stigma, prejudice, and ignorance. And so that is a go-to case that whenever there are cases of unfair discrimination, lawyers should be pulling out and relying on that case to argue to courts that this is simply not acceptable. It's also important to note in this case the important role played by civil society. The AIDS Law Project came in and played a critical role in bringing necessary evidence that dispelled untrue statements that had been made by SAA and poorly justified medical assertions that were made. So that just underlines the importance of civil society. And the last case then that I want to bring to you, which I'm sure you're all very familiar with, is from 2002, which is the Minister of Health versus the Treatment Action Campaign and others. And this was the case that dealt with the provision by the state of nevirapine, which is an antiretroviral drug, and particularly for the use to lower the instances of transmission between the mother-to-child transmission during birth. This is a very famous case. It was also accompanied by a big public campaign. And what basically happened in that case is the government had limited the use of nevirapine to various small pilot sites in the country. And they said that they couldn't broaden the availability because they needed a full package of counseling and of treatment and testing and antiretroviral therapy and the option of substitute feeding. And so they hid behind that to justify not distributing this more widely. And TAC bought the case, and ultimately the court ruled that the state was required to make nevirapine available at public health facilities, and it set out a long order setting out what government was required to do in order to ensure better access to nevirapine. And we all know around this time there was a lot of those are the reasons the government gave, but there was also a lot of distrust of antiretroviral drugs, a lot of uncertainty about HIV and AIDS, or not uncertainty in the medical field necessarily, but just public stigma. And again, the court took quite strong action against government in what some argued was a policy-rich area that shouldn't be the realm of courts. It should be the realm of the executive. But the court intervened quite strongly there. So again, it's an instance of a constitutional court case, which is the top court in the land, intervening and protecting the rights of people with HIV, who are HIV positive and have AIDS. So that's some examples of the case law that we have, and that we have it in our toolbox that we can marshal in these cases. And there are a number of legal avenues for people to go. And that's my next point that I'll touch on briefly. And it's clear that Show Me Your Number is an organization that is educating people and assisting them to go along these legal avenues and to litigate. There's particularly two I'd mention is the Labour Court, which deals with employment issues, but also the Equality Court, which was brought in terms of the promotion of equality and Prevention of Unfair Discrimination Act, which people call the Equality Act. And that established equality court, which are at the magistrates courts level and the high court level, but they're supposed to be, their procedure is very informal. And so it's supposed to be informal and very easy for people to self-represent and inexpensive. So it's not lawyerly language or formalities that you have to jump through. People can go make a complaint, do an affidavit, and they can self-represent if they want to in those courts. And it's supposed to make it accessible. So that's important to remember, that you don't only have high courts, you have equality courts at the magistrates level that are very accessible. And finally, just briefly, I want to touch on how to improve chances of success of these cases. And the first is that it's very important to have civil society involved and campaigning. And that's, we see with the TAC case, where there was a very strong public campaign by TAC. And that created an atmosphere in the news, and judges aren't immune to that. Judges are people, and they read the news and they see these sorts of campaigns, and it created massive public pressure on the courts to do something. And you can contrast that against another fundamentally important case on housing, which is the Grootboom case, which didn't have that kind of social movement. And the result was that the Grootboom court order wasn't well implemented, whereas the TAC order government did in fact implement. The other is, which we've already heard about, so I'll touch on briefly, is the importance of using legal networks, getting pro bono attorneys, pro bono advocates on brief, because these are very important cases and there's a lot to be gained from having assistance and having pro bono. And there are a lot of people who are willing to help on these issues. And also to get in experts. So in cases that involve deep medical detail, to get experts to set the facts straight, because when there's vagueness, that's when prejudice can come in, because people have some plausible deniability. But if you get in experts to lay out the fact, it's very difficult to do. And finally, it's important to have public campaigns. Once a case is won and you succeed, have public campaigns to spread that and spread that information and further reinforce that social belief that it's not okay to discriminate against HIV positive people. And these are what the courts have said, and get that message out there. So that, I think I'm gone over my time and I apologize for that, but that is just briefly from a lawyer's perspective, how I suggest using the courts, using the resources available to combat stigma. Thank you very much, Chantal. That's all for me.
Thank you, Emma, for that excellent overview of the cases. And now it's time for a Q&A session. Unfortunately, Dr. Heffer is unable to join us. He's had some personal circumstances to deal with. So for the viewers at home, you can actually post your questions on the YouTube channel, and I will then read them out to our presenters. But if I can hand over perhaps to Alice and Teresa, if you have any questions for the presenters. Okay, it seems we don't have any questions from Teresa and Alice, so I'll start.
Sorry,
Is that in your... Teresa's back with us.
Sorry. I just had I have a question for Emma on bringing cases, and I just want to thank both of our presenters, both Emma and Mabalane, for interesting presentations. But just for Emma, on the litigation now in today's kind of environment, from what I was hearing, it's like the early cases were about privacy and the breach of people's rights to privacy in the courts. And then under Hoffman and the Nevarapine cases seem to be clear instances and acknowledged instances of discrimination against people with HIV. So it was stated that SAA didn't want to place people with HIV in cabins, and Nevarapine, they stated that they were purposely limiting the rollout of Nevarapine. So that was a clear violation. So in today's atmosphere, I'm just wondering, there has been a lot of communication about HIV and AIDS and TB, and a lot of education around people's constitutional rights. So particularly in the labor environment, where you may not have an employer who is stating their intention to discriminate against people with HIV or TB, but somehow that someone in their employ has it, and then that person experiences discrimination in such a way where it's not overt. We know how these things happen. I'm just wondering if there's been any cases where there wasn't this type of overt discrimination and or stigma, and how those cases are argued, or if you have ideas on how the courts would rule in such cases.
Thanks, Teresa. That's a really interesting question, because I think you're absolutely right. I think people now understand that it's not appropriate to overtly say that you're discriminating on the grounds of HIV, and that there is more hiding it behind other facades. I can't off the top of my head think of a case, but I'm sure there are cases. I mean, there are also a lot of cases that don't get reported in the law journals, so we don't necessarily get to see them. But there are two answers that come to mind, so we've already heard about the importance of detailing exactly what happened and getting as much information as possible. So Show Me Your Number, it sounds like, does a very good job in educating people in how to take down exactly what's happened. Because when people say something to each other in conversation and it hints at the discrimination, it's important to immediately go and write it down or put it in an email and say, I want to confirm that you said this to me today. Because those cases, they become harder to prove, because you're not just saying there's a clear, direct statement, but you're saying, I'm inferring from all this information that they've given me, and all these circumstances together show that it's a discrimination. So the importance of writing things down as they happen, of recording them in letters, recording them in emails, and creating as much corroborating evidence as possible at the time, so you can show that while it was fresh in your mind, you did it. That's critical in order to get these cases. So that's the first answer, is that it becomes much harder in terms of evidence to do it. So you got to be much more careful for evidence in the evidence you record. The second is that there is this, and has been for a long time, the idea of indirect discrimination. So you don't only have to have direct discrimination on a certain ground, you can have indirect discrimination. So an example is a recent case about domestic workers not being able to claim from the COIDA, which is a compensation fund. And the court held that that was indirect discrimination on the basis of gender, because most domestic workers are women. And so it can be when you see something where there's a high correlation between two things, like being a woman and being a domestic worker, or being Black and living in a certain area, that the court will hold that there was indirect discrimination. So that's also worth remembering. If there's a clear indicator that can link you that says they're discriminating against this group of workers, but those workers are more vulnerable to HIV or more likely, then you can establish indirect discrimination. That's.
Hi. Thanks. Can I put a question to Mabalane, please?
Yes, please, Alice.
Great. Thank you both, Emma and Mabalane. And I just wanted to ask, in terms of a focus on civil society and community-based organizations, right, in the context of HIV/AIDS and TB, Mabalane, tell us about the impact of COVID-19 and the restrictions and, the aftermath and the repercussions of that virus on the ability of advocacy groups to do work around HIV and TB. Just give us a little background on how that's playing out over the last several months.
Thank you, Alice, for that question. The COVID has brought challenges, but also has pushed us to embrace technology and do things differently from how we used to do them. And so the impact of it is that our ability to come together, to advocate, to determine the course of action in terms of taking up various issues has been curtailed to a great extent, and that has shifted us to embrace technology and do things from a technological space. And that has had an impact on the impact that we can have, and we have had in the past in advancing our agenda. The second part is in terms of the interface between those that require services, people living with HIV, people living with TB, who ordinarily have to go and interface with the duty bearers, especially in the health facilities. The regulations have impacted on the ability of people to access services as they ordinarily would have during the when we didn't have the regulations, including during the lockdown. But also, given what is reported in the media in terms of the impact of COVID, especially in terms of the frontline workers in the health facilities, people being afraid of contracting COVID when they interact and interface with the health facilities, that has had a negative impact on people accessing medication. Emma was talking about the TAC case that paved the way for people to access antiretroviral medication, and South Africa ramped up its ability to provide medication to patients. There's been innovations that have been put in place to ensure that people continuously receive their medication, sometimes out of the facilities, but because of challenges around technology and other issues of drug stockouts and so forth that people have experienced. So some of those innovations have looked at how to provide services outside of the health facilities, but there is still a sizable number of people who only are able to access their medication by interfacing with the health facilities. So with COVID, the attitude of the health facility, given what has been reported in the news, is I'm putting it in inverted commas, protecting itself from potential, from people who can potentially bring COVID into the facilities. But those people go to the facilities because they need to have access to their medication. That has had an impact in terms of, a default rate that has gone up, the ability of the health system to provide services. That has prompted the department and other role players to try and up their game in terms of dealing with the backlogs that have come on board as a result of the impact of COVID. So at both levels, at the apex is for us to ensure that services are not disturbed, but it's also dealing with the attitude that comes in. And sometimes the attitude are as a result of people, overtly or covertly bringing to the fore some of their prejudices, as colleagues have been talking about, what some employers do, which is what they don't write down, but how they approach issues is discriminatory. So, but in the main, we have been pushed to embrace technology and ensure that we use it. Similarly, as Mr. Delivery and Uber and others who are in the technology space, the COVID, whilst it has had an impact, it has actually made other businesses to boom, especially those businesses that are within technology space that require the interface not to be a human interface, but interfacing through the various platforms. So yeah, I think we're working around it to ensure that going forward, we have a hybrid model that allows for on the ground boots on the ground that put pressure, but at the same time use technologies as another platform to ensure that we ramp up our ability to access services. And Chantel, I have a question for Emma on what she said regarding the equality courts. The way you put it is, it's an easier platform that can be used to address issues that require a legal intervention. So I just want more detail in terms of what type of cases should be taken to the equality courts, and the modality, or how long does the equality court take? Because sometimes the law can take a long time, but how long does it take when you have an issue that qualifies to be addressed by the equality court? The period that those courts address the issues that are provided to it, as you have articulated it well, that it's another platform through which individuals can actually use that without necessarily having the support of legal support. Thanks.
Thanks, Mabalane. So the equality courts they have jurisdiction over the Equality Act, and the Equality Act has, so one of the main things or the actions you can bring are anti-discrimination. So the Equality Act has a prohibition on unfair discrimination, which would include discrimination on the basis of HIV. It's also any kind of harassment that people would experience. So it also, if you have a claim for harassment against people where you've been harassed on the basis of your HIV status, you would also be able to go to the Equality Court. And they also deal with claims of hate speech. So any kind of hate speech that is experienced of people inciting violence in relation against people with HIV. And the last one that I think is applicable is publication of discriminatory material. So it also deals with if you publish, if there's someone publishes material that is understood to be, reasonably understood to be discriminatory, you can go to the Equality Court. And the Equality Court can give, it has a very broad discretion about the kinds of remedies that it can give. So it can give money, it can seek an apology, it can also, it has discretion to ask people to do other sorts of things. It can also intervene in sort of employment, say you have to fix whatever you've denied a person by discriminating against them and afford them that advantage. So it's very useful because it's got quite a flexible range of things that you can ask for. And it's more informal. So those are the kinds of cases. So I've taken a lot of discrimination cases there, and I've taken harassment cases there, and those on any of the prohibited grounds, which include things like race and sexual orientation. So it's useful for that. It's also very informal in that you can go to a magistrate's court, and most magistrates' courts will have someone designated as the equality court, and the clerk will then help the person fill out the form. And in filling out the form, that includes an affidavit that says exactly what's happened. They happen quite quickly relative to other cases. So it all depends on how busy the court is at the time. But I think in matters that I've been involved in, often the hearing will happen within 2 months of going, which for other trials is absolutely unheard of. For trials, you can wait a year, which obviously isn't, the law still moves quickly. You'd like an immediate solution, but you can move relatively quickly. And then the question is how long, if there's evidence, people standing in the witness box, how long that takes, because sometimes it might take a few days and then it might get postponed because you haven't covered all the evidence. Or if you can do it quickly, then you can cover it in a day or two and then have that finalized. So I've had good experiences in that respect. The only problem with the Equality Court is because it's so informal and supposed to be very flexible and casual, sometimes you don't know exactly what you're supposed to do next because the rules aren't clear, and the judge is supposed to give you clear instructions on what happens next. So it's important to ask the judge and be in lots of communication with the judge and the clerk to say, what should we do next? This is what we propose. We want to put in another affidavit, or we want to get a supporting affidavit from this person, and then we can go to trial. So it's important to be quite proactive when you go to the Equality Court, not just leave it in the court's hands, but you actually do have to take a lot of steps and push for things to happen quickly. But you can also then push for things to happen on a faster timescale, which is useful. Yeah, so it's worth investing in. So I have a question for you, Mabalane, and that is, you have a lot of grassroots access to people, and what are the kind of complaints you get that would turn into legal cases? Are they complaints about privacy issues? Are they mostly discriminatory issues? Are they harassment issues? What sort of stuff do you see on the basis from vulnerable people who are HIV positive?
No, thanks, Emma. Most of the cases that our mobilizers, the reactors are getting relate to the health system. So it's people and their interface with the health facilities, but also a discrimination that comes, especially for the LGBTI community, which I did not mention as part of the vulnerable communities that we have, especially when they go report cases in police stations. They are being discriminated in terms of, frontline duty bearers, not really, not taking people's, choice of their, their the word just fails me now. But yeah, discrimination based on a person's sexual orientation. Case issues where we will not deal with two men who should not actually be having a relationship. Those discriminatory practices that people have. That's what most of the people in the LGBTI experience in terms of the health facilities. But because and then in terms of the police settings, and what that has prompted us is an ongoing process of reorientation and ensuring that the frontline police, including management, they unlearn their prejudices and serve people as human beings. I may have a partner and we may be of the same sex, and we may have same problems as a man and a woman have. And when a woman comes and reports a case, the same vigor that you use to report, to address that, addressing issues does not depend on what your sexual orientation is. So ongoing training around that. But if there is resistance from the law enforcement to, be whipped into line by understanding that they must treat us as equal partners, then the law needs to be used, including supported by advocacy, so that these practices, which in some areas, are actually, they are done with impunity by those that do them, because nobody does anything to them. They are the law and they can do anything as long as they are on uniform. The other biggest one is in terms of at health facilities. There are some discriminatory practices that individuals, and not the whole system, individuals, practice. For an example, a young woman, and we have used this in the trainings that we have done. At 12 years, you can have a termination of pregnancy. It's in the law. But you can vote. You vote at the age of 18. You get an ID at the age of 16. You can, consent for sex when you are 16 and above. So, but you are a 13-year-old who is pregnant, and you want to go and terminate pregnancy. Now, there's a law that allows you to terminate pregnancy even without consent of your parents, because although you are underage in terms of you are not, you don't have a right to vote and all those other things. So, at the health facilities, there are now those prejudices where people want to understand, why do you want to come and terminate pregnancy? Where are your parents? And this has nothing to do, with the parents, because it's prejudices that people bring into their space as duty bearers. So those are some of the key challenges that are coming out in terms of the issues that are identified on the ground. And the most important thing, I think, as you're speaking, it's also documentation. Now, some people are not able to document properly. They can't read, they can't write, and that has an impact on their ability to put together a case. So I also want to now turn the question back to you. How admissible in building a case would audio-visual documentation, will it be acceptable, like a written thing within the course? Because trying to get the details by getting people to write may actually, whittle down what you can get. But people are able to say their stories and record those particular stories. Will that be admissible, so that we can then also look at ensuring that as the documentation of the human rights violations are done, we also use different methods of documenting. But for now, we've been using written documentation. Thanks.
Thanks, Mabalane. Oh, sorry, my camera's on. There we go. I think that audiovisual is an excellent way of documenting, and as long as the audio is clear. The key is to have some kind of timestamp and identification of who's talking. So if it's just audio, it's useful to say, this is so-and-so, or you're listening to, I'm recording this person. Audio visual is incredibly useful, because that then obviously shows you the picture and puts words to the picture. So I've had a discrimination on the basis of sexual orientation case where someone was shouting at my client and shouting insults, and he got it on a video on his phone. And that we then showed to the court, and that was very compelling evidence. And what happens is the court just gets that transcribed. So they'll just get someone to type out exactly what was said, and that forms part of the record. But that is very good evidence, and I agree with you. For people who can't read or write, having the ability to record sound or record sound and video is very powerful. So that's a clever initiative and definitely something that I would push. Great.
Thanks. Thanks, Emma. Sorry, Alice and Teresa, do you have any other questions?
I am fine for the moment.
So I don't have anything, I don't have any follow-up questions currently. I think the input has been excellent. And some things I was thinking about have been covered in the responses to the other comments and questions.
So I just have a question for both Mabalane and Emma. I mean, Emma, you did an excellent overview of all the cases, and in terms of sort of ending or stopping stigma, you know, we're dealing with stopping sort of this gossiping, which, you know, you can't divulge someone's HIV status. We've brought an end to, or at least a legal end to, discrimination in the workplace. And then, of course, you know, the provision of ARVs. So to the both of you, what do you think is the next big case that needs to come before the, you know, before the courts in ending discrimination against persons living with HIV/AIDS?
Mabalane, do you want to go first? Or shall I go first?
You can go first.
All right. I mean, it's very difficult. I would say, I think what Mabalane said, like areas where we see a lot of discrimination that has quite high impact is things like policing and healthcare. So where people, you know, I've heard of a lot of discrimination of people's complaints not being entertained or charges not being laid at police stations on the basis of prejudice of police. So I think that there's that possibility. I mean, it all goes down to the same principles about discrimination, but it could be quite powerful to give that particular organ of state a fright. And so possibly there, but yeah, that's just, I would have to think about that, but that's what comes off the top of my head. Yeah.
Yeah, I think for me, I mean, it goes to some of the issues that I've already spoken about, but it's to smash the prejudice that people have, including social and cultural prejudices that they bring into their role as duty bearers. So, you know, the choice, termination of pregnancy as it relates to an underage young person, you know, given that the statistics also indicate that people that are most affected and where numbers are rising in terms of new HIV infections, it's adolescent girls and young women. And mainly it is not because they have chosen to be pregnant in at the ages that they are. So most of the time it's not a choice that a person, you know, basically has. But people bring into that interface their religious and the cultural beliefs and denying the, you know, the adolescent girl to exercise the right that are enshrined in the law and are, you know, are part of our constitutional responsibilities. So for me, is ensuring that we bring a case of that particular nature. In a way, it's not to encourage for young people to be pregnant. We would really not like any young person to be put in a situation where they become parents before they enjoy their youth. But those that find themselves in a situation where they did not have a choice must actually not have their right to, you know, their rights trampled upon by those that hold power through provision of health services by demanding of those young people things that are not required in terms of the law. So that is one I would actually look at. But the other one, of course, because of the it's about unlearning our prejudices in terms of the LGBTI communities. So it's really ensuring that these are not just things that are spoken about. Most of the cases that come to the fore are about people who kill people for their sexual orientation. But the most cases that don't come to the fore are the discrimination that they experience as a result of those that are supposed to provide them with services, especially within the law enforcement, primarily, the police. But those things also happen to them in terms of health, health as well, because there are some of the choices that they want to make, and they are denied those particular choices because others have, abdicated to themselves the responsibility to be the mini gods and say, no, this is not according to what the Bible and the preachings and whatever are saying. So it's a combination, or any one of those two as the biggest thing that must smash our prejudices as society.
Okay, great. One of our previous speakers actually mentioned that there's just been a lack of cases on behalf of children living with HIV/AIDS. So, for example, children who are not adopted solely based on their status, or children who are denied access to school. So, Mabalane, I think it's really great that you brought up the adolescent issue, because it's something we tend to forget about. So, if there's no more questions, then I'd just like to hand over to Alice. This morning's been an excellent discussion. It's been a great synergy between the legal practitioners and civil society. And I think the discussion has really brought up some synergies on how we can work together and actually further the cause. So Alice, I'll hand over to you now.
Thanks, Chantel. And yeah, I just have the privilege of saying thank you to Mabalane and thank you to Emma for these excellent presentations, very thought-provoking, and hopefully they will help stimulate more pro bono support for these efforts. That would be great. That's our hope and prayer. I also want to say thank you to Chantel and to Marco, who have put these webinars together and are working both in front and behind the scenes to make things work. And then to say thank you to the audience and the participants, and also to please ask everyone to encourage, their network of colleagues to participate in these webinars and to kind of take on these issues, both, with regard to legal practitioners, but also with regard to the on-the-ground community activists and the like. So generally, it's just a big thanks to everybody who's involved in these issues, and to say, the good fight continues. So we need to be out there on the front lines. Thank you.
Thank you very kindly. We will move on with the journey to make South Africa a country that is great for all of us.
Yes, and from my side, thank you so much. And thank you also for the excellent work that you do pro bono. I think you are an important avenue for people to address these considerations. So congratulations to you. Thank you for your work.
Thanks to you both for joining us and, donating your time, from your busy schedules, I'm sure. So for me, it's been an eye-opener, and I've learned some things. So thank you very much.
Thanks.
Thank you, siyabonga.
Thank you.
Thank you. So just a reminder to our viewers, if you would like to get involved in more pro bono work with HIV/AIDS. The website has got a number of resources that will assist you, including a number of the cases that Emma actually discussed this morning. So if you're looking for a quick reference point, we really encourage you to use the website. And these webinars and some of the YouTube videos that probono.org has created will be on the website. So please, we encourage you to get involved. And we really hope that this has inspired you for legal practitioners to really expand themselves and offer more of their pro bono time to this important topic. And of course, that we can work together with civil society. So this will all be emailed to you so that you can just easily find the references. Okay, thank you very much to everyone, and we hope you have a fabulous day. Okay, bye-bye.
Thank you, bye.